The presence of a notary at a general meeting, far from being a mere formality, brings in safeguards and specific rules that legal decisions have made clear in different situations where there's a disagreement. We will look at court decisions that answer common questions. The first and most important question is, can a general meeting be held without a notary if a minority shareholder has asked for one within the time limit? The court's answer is a definite no. If the meeting happens without a notary, even though a shareholder asked for one on time and said they were against it at the start of the meeting is not valid and its decisions have no effect. Not being able to find a notary is not a good excuse. Once the notary is there, questions come up about their job. How should the notary act at the start of the meeting? The notary must check that the meeting was called correctly. If not, they must refuse to take part. Also, once the meeting has started, they must ask if there are any concerns or objections about the number of shareholders and the capital that is present or represented. This helps avoid problems later. But, should a notary make the list of people attending? No. This job belongs to the meeting's president, with help from the secretary. The notary only writes down in the meeting notes what the president says about these things, and any concerns or objections raised by the shareholders. The secretary's role also changes when a notary is present. What part does the secretary play, if any, in a meeting with a notary? While the notary takes over the secretary's job of writing and signing the meeting notes, the law does not remove the secretary's other support duties, including making the list of attendees, which is still their responsibility. Finally, a common and tricky situation. What should a notary do if a shareholder in a meeting says that a decision is against the law or even wrong? The notary does not have the job of deciding if decisions are legal or if the people running the meeting are acting correctly. Their job is only to check if the person asking for their service has the right to do so and, except in universal meetings, to confirm that the meeting was called according to the law and company rules. If not, they should refuse their service. In the previous video, Calling Meetings, Court Answers to Common Problems, we looked at questions about how to call a meeting. In the next video, how far does your right to information as a shareholder go? 10 very common questions finally answered. We will look at another big challenge in general meetings, the right to information. Ask your questions and challenge our AI Atenea. Complex questions, expert answers. More information at ilpabogados.com.